1.
The clerk will open the court.
Oyez, oyez, oyez. The Honorable Court of Criminal Appeals is now in session.
We are ready to hear argument in cause number PD-0243-20, Sandra Jean Melgar versus the state of Texas. You may proceed.
Good morning to the court. I'm George McCall Seacrest Jr. from Houston, and along with Allison Seacrest, we represent Sandy Melgar on appeal and represented her at trial. The state did not prove Sandra Melgar's guilt beyond a reasonable doubt. And I contend, based upon a fair and full reading of the record in this case, and based upon its unique facts, the evidence is legally insufficient as a matter of law.
Counsel?
Yes,
Counsel,
Your Honor.
Just to at the outset, I want to make clear, are you arguing, or are you saying, is there any dispute between you and the state as to what the standard is for legal sufficiency? Or is this a situation where the argument is over whether the standard, which everyone agrees on is correct, was still improperly applied?
Well, I quite frankly, I think it's a little bit of both, Judge Newell. I've been critical of the fact that I do not believe that the state has acknowledged the rationality component of Jackson versus Virginia, and more specifically, the standard explicated in Brooks v. State. I've been critical of that. But when the dust settles, what is before the court is a pure question of law based upon the 4 grounds of review that we filed in our PDR.
Okay.
Did I answer your question?
That's as good as I guess I could expect. What I guess that I would drill down into this other question then.
Okay.
If at what point, or what is missing from the case or the record that you think needs to be there in order for the jury's determination to have been rational?
I believe that many of the inferences that the state and the panel opinion contend are supported by the evidence, in fact, are not. I believe that it is fueled by speculation and theorizing about the possible meaning of evidence. I also think the state has set up an argument that basically this is no more than a credibility of the witness contest, and because the jury returned a verdict of guilty, therefore there's nothing for the court to consider. But of course, under Jackson versus Virginia and its progeny, the fact that a jury is certainly charged with credibility determinations, its ultimate conclusion is still subject to review on appeal. And we believe, again, that when you look at the totality of the evidence, that the state clearly has not proven the case beyond a reasonable doubt. What's particularly disturbing, beyond the several mischaracterizations of the evidence in the Court of Appeals opinion, as we set out in our brief, but the Court of Appeals has sanctioned fact finders arriving at an opposite conclusion of the witness's testimony based on purported non-belief of the witness. That's antithetical to Texas law. And this is a direct quote, it's in the brief, based upon the case law from this court and other courts of appeal. Disbelief of a witness may not be used by the trier of fact as affirmative support for the proposition that the opposite of the witness's testimony is the truth. And that's what the Court of Appeals did in this case in several respects. They also basically held that if a jury disbelieves Sandy or witnesses called in her behalf, if those credibility determinations were adverse, then that's affirmative evidence of guilt. Well, the other part of that is, however, as Professor Dix has said over and over again, as this court has stated in its seminal case of Gold v. State and the other cases that I cited in the brief, whether or not a witness is believed or whether or not the defendant is believed, that does not constitute evidence beyond a reasonable doubt. The state still has the affirmative duty of proving that Sandy Melgar actually murdered her husband. And when you look at the evidence in this case, they didn't get there.
Okay, well, that's a good, I hear what you're saying about the idea that that we're only supposed to look at what the evidence is there, and then we're supposed to infer or see whether the jury was rational to infer from the evidence that was there, not infer from credibility determinations that evidence is not there, could have been there. But I guess what I want to know is, it's always a tricky line figuring out the difference between a rational inference and speculation. So looking at all the evidence that's there in the most favorable light to the verdict, where does it stop? You know, what is the evidence that we have in the light most favorable to the verdict? Just the evidence we have, not the evidence that's not there, not any contrary. What is it we have, and then that show that the state has proven in this case, I guess?
I don't believe the evidence that you have shows that the state proved that Sandy Melgar killed her husband. The state proved that she was present. But if you look again, as the court well understands it has to, if you look at the totality of the evidence, they didn't show that she actually killed him. Now, they can rely on circumstantial evidence. Obviously, they can do that, but the circumstances must be based on actual evidence in the record. In this case, as we painstakingly pointed out in our briefs, and we thank the court for letting us file an enlarged brief, in this case, when you look at the evidence and the totality of the evidence, you have this primary theory of the state was that she killed Jaime and then she cleaned herself up in the bathroom. The evidence affirmatively shows that that's not the case. The CSU testimony was that application of reagents showed absolutely, as a matter of physical science, there was no cleanup. Of course, the state and the panel can contend, well, maybe she cleaned herself up elsewhere. But the reality is the evidence doesn't support that either. The evidence, when you look at the brutal nature of the assault, and that's somewhat interesting, I find in the state's brief, they talk about the stab wounds as we do, but they assiduously stay away from talking about the brutal nature of this assault. He was subjected to blunt force trauma on top of 31 incised stab wounds. And those blunt traumas were on the back of his head, the top of his head, both eyes had orbital fractures. He was viciously assaulted. He was beaten, consistent with being hit with a fist, consistent with being kicked. And when you look at Sandy Melgar's hands, she doesn't have an injury on her hand. She doesn't have a broken nail. It's just not plausible under the circumstances that she could have caused that type of injury. The medical examiner said she couldn't rule out the use of more than one weapon. The CSU investigators testified they were not saying that someone could have broken into the house and left the scene, without leaving any blood trace behind. They were not saying that. No blood is found on Sandy. No blood is found on her clothes. Disturbingly, the scene detectives, in a conversation with the CSU investigators, told them not to examine Sandy's clothes. But the examination of the clothes in the closet and everywhere in the house showed the presence of no blood. Disturbingly, if Sandy was the perpetrator and she didn't clean herself up in the house, then where did she clean herself up? Well, okay, maybe she left the house. There's no evidence she ever left the house. And for some reason, they didn't bother to use fluorescein reagents on the cars to determine whether or not there was any blood on the exterior or interior surface of the car. So, yeah, I can go on and on. The evidence with respect to the evidence is that she was found tightly bound in a closet with a chair crammed underneath the exterior doorknob. That's undisputed, uncontradicted evidence. The Court of Appeal says, well, she was tied up at the wrist. That's not what the evidence is. The undisputed evidence is that she was tied up from the wrist up the arm to the elbow, and CSU photographs confirm that she had red linear marks consistent with those bindings when the CSU photographer took the photographs. They did a demonstration at the scene on how somebody could perhaps move a chair underneath the exterior doorknob. The problem is that would require that the chair be on the sham, and the evidence was that the sham, in fact, was not under the chair when Herman and Maria Melgar came in, nor was it found in the closet.
Is your position then that the jury could not have believed that this was staged, or that it could not have believed that she set herself up to be tied up in the closet, or could they have believed that she did it?
I don't believe on this evidence, Judge. When you look at the evidence, I know jurors are supposed to decide conflicts in the testimony. There is no conflict here. The state offered no evidence in any way to rebut the testimony that she was tied up so tightly that she had to be cut out. The prosecutor did a demonstration in front of the jury, which is not evidence. But in any event, the record clearly shows that the demonstration that the prosecutor did was not in any way like the manner and means in which Sandy was tied. The prosecutor tied herself up only by the wrist using a different material. And also, the position of the prosecutor's arms and wrists were different than that reported by the witnesses. Now, I will say this, ultimately, sure, a juror could ultimately say, I don't believe that witness. Yeah, a juror can do that, but the ability to reject a witness's testimony, as this court has held in Broughton, must be rational in light of the totality of the record and all underlying inferences. In order to reject the testimony must be reasonable based on the cumulative force of the evidence.
I guess one of the things I'm kind of getting at, though, is let's assume that we look at the record, or we have listened to the state's brief, we're persuaded that the jury could have inferred that she set it up and tied herself up in the closet. Is your position then that the jury could not then take that evidence, and having reached that inference, that they could not then say she committed the murder too?
I totally agree that they could not. Again,
Okay.
I don't think they could, Judge Newell, I don't think they could reach that initial first piece rationally or reasonably. But even if they did, the state still has the burden of proving each of the elements beyond a reasonable doubt, and their disbelief does not establish the opposite of their testimony, nor does it establish her guilt beyond a reasonable doubt. What the state has done here, and what the Court of Appeals has sanctioned, is basically lowering the burden of proof. They're allowing the state to discharge its heavy and strict burden of proof based upon a notion that, well, the jury didn't have to believe certain testimony, therefore the state must have proved its case. That's not what the law is.
So let me ask you,
that violates due process. Yes, Your Honor.
yeah, let me ask you a question real quick.
Sure.
So I know the state doesn't have to prove motive. They speculate about what your client's motive might have been. But if there's anything in the record or in the briefs I missed, is there any evidence of any, what would the motive to kill Jaime have been?
Zero. Let me
I mean,
tell you.
no, not for your client. I mean, for someone else to kill him.
Oh, we believe it was home invasion, and that would be the motive. We believe that, in fact, people entered the home. We think this business about no breaking and entering, the garage door was up. It was an unlockable interior door, and there was, contrary to the Court of Appeals opinion, there was evidence that property was missing. Opioids were missing, a television set, jewelry, cash. that is the motive
And
for
why
why someone else did it.
Why would they not have killed your client too?
I don't know. I'd have to speculate. I believe a fair reading, but you asked the question, I believe a fair reading of the evidence is that when they came in, they initially had a struggle with him when he went to check on the barking dogs as reflected by the dog hairs and the dirt on his body. And that she had gotten out of the hot tub and was sitting in the closet, reaching down to put on body lotion on her legs, and the body lotion is found right there. She's hit on the head. She's got a hematoma on her head. And they ended up killing him, and they bound her and left her and decided to leave. That's the best I can do, but I'm
So they didn't need to kill her.
They didn't need to. No.
Okay. Thank you.
Also,
Were you going to save some time for rebuttal?
yes, I will. Thank you very much.
Okay, thank you.
May it please the court. My name is Clint Morgan. I'm an assistant district attorney of Harris County, and I represent the state of Texas. This case is about the Jackson standard and this court's obligation to let the jury be the one to determine credibility and to limit its review to the sole question of whether any rational finder of fact could have found guilt beyond a reasonable doubt based on the evidence presented.
Counsel, just to ask the same question I asked defense counsel, is there any legal dispute over what the standard is, or is this really just a question of how the standard has been applied?
I think it's a question over how the standard has been applied. There's an awful lot of discussion in Mr. Seacrest's brief about whether or not you consider all of the evidence. And of course, Jackson says that you do. I think applying the Jackson standard there means I termed it disregard. I don't know if the case law uses that terminology. It's kind of odd because most sufficiency cases are, did the state get from point A to point B? Not
Right.
Did the state get from point A to point B and then defensive evidence push it back, which is what we're looking at here.
Well, that's actually I appreciate you saying that, because I guess the thing I see in this is going to be about where the gaps are and how big those gaps are. So where are they? Where are they? And why is it that, in your opinion, the evidence and the jury could have leapt those gaps, or have inferred past those gaps?
Sure. There's a lot we don't know about this case and about what happened. And there's a lot about the crime scene that's quite peculiar. I think the way that the blood is very localized in this case, given the amount of blood, it's just nowhere else in the house. And that's truly fascinating. It's hard to say which way that necessarily points. I think it points more towards her than anyone else. But at the same time, it's one of these facts in this case that makes this peculiar, and it leaves us with a lot of gaps about the exact details of what happened. So we ask, what could the jury have inferred? Could the jury have inferred from this evidence beyond a reasonable doubt she was there with him alone at the time of the murder? If they could have inferred that, an awful lot of things fall into place, because if she was alone with him at the time of the murder, well, Hooper, the hypothetical at the end of Hooper tells us what conclusions we can draw from that. We start looking at other circumstances in light of that circumstance of guilt. And so if she's there alone at the time of the murder, well, by definition, she had to have done it. And it's possible for her to have done it, right? There's nothing disproving that. And so the question is, what evidence was the jury required to believe that would prove someone else was there? What evidence are they required to believe that would raise a reasonable doubt as to whether she was alone there? And the evidence of home invasion here is spotty at best. We have testimony that has looked staged, does not look like a typical home invasion. The pictures are in the record. Many of the drawers are open, but not rummaged through necessarily. There's an awful lot of stuff that's still around, including some visibly valuable items. There's the fact that, frankly, it's very curious that no one would have killed her while they were doing this. This was a truly brutal murder. Who would have the incentive to go absolutely bananas on him with all of these stab wounds and all of this physical damage, but was content just sort of, I don't know, tying her up and walking away from that? That's an extremely brutal murder that it's not typical for a home invasion style. So they report some stolen property. That would be pretty good evidence of home invasion. However, all of that is based on the testimony of the defendant's statement and testimony of her family members. And this court simply, under the Jackson standard, there's nothing there to make that this court can hold the jury was required to believe that. I understand Broughton has some discussion of rationality of rejecting a witness's statement, but ultimately things that determine whether we believe witnesses' statements and believe witnesses when they testify, much of that will never appear in a record. It's all demeanor, which is why it is so vital for this court to defer to credibility. But if this court wants a rational reason to find that the jurors could have disregarded certain testimony, they could have believed that this was staged from the beginning. There's evidence of that. There's evidence she was there by herself. And in light of those circumstances, it would be completely rational for the jury to disregard, to discredit the evidence of a home invasion that came exclusively through witness testimony.
Counsel, let me ask you a question. You, in your brief, you say that the jury could have disbelieved the family members who were first on the scene, that they might have been lying, or they might have been mistaken, or they might have been so upset that they didn't really pay close attention to the things that they later testified about. But is there a limit to the rationality of disbelieving witnesses? For instance, could the jury disbelieve that the family even showed up at the house when they said they did? Could they have disbelieved that Jaime found the defendant tied? I mean, could they have disbelieved everything family said, or is that irrational?
I don't think it's necessarily irrational. It would be irrational if, in the instance mentioned in Brooks, there's a video showing the actual event and it's plain what happened, and then the jury's like, no, we're not going to believe that. In the circumstance in which it is strictly witness testimony, I am unaware of any legal standard, any case applying the Jackson standard saying the jury was obliged to believe witness testimony.
I mean, even if the state didn't dispute it, I'm assuming the state didn't dispute Herman's testimony about him arriving at the house. Could the jury disbelieve that anyway?
Couldn't they?
I'm asking you.
This is always the case when we let fact finders determine credibility. We have to say that they're able to disregard certain things. The fact that we didn't dispute it is true enough, but how would we dispute that unless we had our own witnesses there? There's somebody who's saying a thing, and to hold that a jury is obliged to believe the person saying a thing when there's no physical evidence. I mean, there's a house. That's some physical evidence that he was inside the house. There's some bindings there. That's some physical evidence of this. Do they have to take this man's word or anybody's word about how those things got there? And
Okay.
that's not how the Jackson standard works.
Thank you.
Thank you, Your Honor. And I think that's very important because this court in other contexts has recognized that the idea that there is undisputed testimony does not mean the difference between uncontroverted and undisputed testimony does not necessarily mean that everybody is accepting that as the truth, right? We fit a theory of guilt at trial within her being tied up because the evidence seemed to show that we had no actual evidence that she wasn't tied up. And we fit a theory of guilt within that, showing that she could have tied herself up, that could have been staged. But my point is that on sufficiency review, the job of this court is not to ask what it believes or even what this particular jury believed, but to look at what the evidence showed and whether any rational fact finder could have believed that. And if we had said simply she was never tied up, we don't believe that. Do you believe that? That's a question of credibility the jury was allowed to make. And they have to be allowed to make that under our system that defers to findings of fact and credibility to the jurors. And so the mere fact—
Mr. Morgan.
Yes, Your Honor.
Mr. Morgan, could I ask you a few questions about something you mentioned earlier? I think one of the first things that you mentioned is something dealing with the lack of evidence of forced entry. Okay. So I guess the first question is, how important is this lack of evidence of forced entry in this big puzzle? Is it a small piece in the puzzle or a big piece?
I think it's a medium-sized piece in the overall gist of it. It's true the garage door was open, but as the 14th court pointed out, the jury could have inferred she opened that to let in the people to rescue her at a later point in time. Had there been evidence of forced entry, I think that severely undermines our case, but there was not. And so this is the sort of thing that the absence of it accrues to the benefit of the state here, because I mean, it does not persuasively show that there was anybody else there at the time.
Okay, let me ask you this question. Did the garage doors have door openers on them?
Yes, they were electric. I believe they were electric garage door openers with buttons on the inside and
Okay.
remote clickers.
And I think I read that her car was in the garage. Is that correct?
Yes.
Okay. Did he have a vehicle that was outside of the garage?
I believe so.
Do you know if anybody to check to see if the windows were down and some intruder could have just opened the door?
I believe the door was locked, but I don't remember specifically that point. That's my recollection, but I may be wrong.
Okay, so I was reading in your brief on page 28. You say that she claims the fact that the garage door was open shows it was fallacious for the state and 14th court to rely on the lack of evidence of forced entry. Then you say, but the only evidence the garage door was open at any relevant time was testimony from the appellant's family members. When I look at that first, it does make sense. But then based on what you're telling me here, on what you think the facts were, I have to wonder, how would the family members get in the house if the garage door was open and there was no forced entry? You know what I'm saying?
Yes, and this
in other words, they had to get in the house somehow. So isn't that some evidence that the garage door was open when they got there?
Right, and this goes back to
they didn't break in. The family members didn't break in because there was no evidence of forced entry.
Correct. And this goes back to my point about what facts was the jury obliged to believe? And the family members testified that when they got there, the garage door was open and they went in through the garage door. And we have no actual reason to disbelieve that necessarily from the evidence that we have. But the question is, was the jury obliged to believe that testimony and obliged to determine that garage door was open when they got there? We fit a theory of guilt within the garage door being open, and the jury believed that. But I don't know that the jury was obliged to even believe that much, because it is witness testimony. And under the Jackson standard, a jury may disbelieve that on the basis of credibility alone. And credibility doesn't appear in the record.
And is it true that the family members we're talking about was the deceased family and not the wife?
Yes. Yes, it is. It's the defendant's in-laws.
Okay. Okay.
At what point does this formulation, I'm sorry, at what point does this formulation though sort of flip the burden onto the defense to come up with stuff to explain why it's not her versus looking at the evidence here to sort of say why it is?
Sure, and that's what makes this a very interesting case from a standard of review perspective, because we've got her at the scene with her dead husband and no real evidence that anybody else was there. And then
I'm sorry, what about the knot on her head?
Sure. I mean
so you could say that someone else was there because she got hit on the head. I mean, so is the state, proposing that she hit herself on the head or that he hit her and then she stabbed him in response? Especially
right.
Since there was no blood on her. I'm curious about that.
Right. So how did the knot on the head get there? Maybe it predates the whole incident. Maybe, as Mr. Seacrest keeps pointing out, this was a very violent attack and maybe he fought back. We don't really know. The fact that there's a knot on the head is sort of like the fact that there's other people's DNA at the house. It is this circumstance from which you could draw one inference, but on its own, it's just a factoid. It's a freestanding factoid. And Jackson says the jury gets to draw reasonable inferences from the factoids. And all of these things, I agree. You say there's no blood on her, and that's correct to the best of my knowledge. But she was also found 12, 14, 16 hours after the murder. And so that is one of the factoids that the jury was given. And Mr. Seacrest asked the jury to draw one inference from that, and we asked the jury to draw a different inference from that. And
can I ask you a question about what you just said as far as no blood found on her? Do you agree with Mr. Seacrest that the evidence is clear that there was no cleanup of the bathtub or in the shower?
That's what it seems to be. I mean, our witnesses said there was no evidence of that. So yes, I believe that's correct. I mean, the record will say what it is.
What time of year I'm sorry, what time of year did this happen?
I believe December.
December, it's cold. So I don't know if you have any idea about the temperature, because I was wondering when Mr. Seacrest is talking, if she would have committed this offense without any clothes on, could she have gone outside and cleaned up with a water hose? Is that a possibility?
It's, as far as I know, a possibility. I mean, one of the interesting things again here is there's no blood tracks going away from the actual stabbing scene. Which, I mean, that would be weird whether it's her or whether it's a home invader. You would expect some blood tracks elsewhere in the house. So yes, I think that's altogether possible, but there's no affirmative evidence of that. That's I think the jury's ability to fit things together. That's one of the things they could have thought was a possibility given the overall, if she was there alone and that leads to its own conclusions.
But if we're looking at the sufficiency of the evidence and what's really in there and what's rational, the fact, I'm sorry, but reading this record or reading the briefs rather, I'm, let's say, I'll pick a word, fascinated by the fact that it's not rational to me that the forensics in this case are grossly lacking. I mean, they didn't pick up much of anything. They didn't test a whole lot of anything. So, to say that it's totally rational for them to just jump over that fact and, well, there's no blood trail, there's no blood here. Well, half the time the crime scene people didn't take anything. And if all the evidence they have is she's there, is it rational for just them to say, well, she's there, and we don't care if there's any scientific evidence to back up any of these other questions? Is that rational?
Well, so in every case, most cases, defense lawyers will always criticize the quality of the investigation and say you could have done more. And it's always the case that you could do more. Whether or not this falls below some sort of threshold where a jury was completely irrational in believing anything that we told them, that would be under the Jackson standard a heck of a holding. And that's what this was presented to the jury. The jury was told about the supposed deficiencies in the investigation and the things we wished were tested. And we'd always wished that more things were tested. And that's part of the jury's duty to weigh the testimony. That's
true, but now we're in a position of deciding whether that's rational.
Sure.
Correct.
Right. And so had we just shown up, had our testimony been, we showed up to the crime scene and she was there and he was dead. Ta-da. Right. So that's not a rational decision to understand. We showed an investigation. We showed what I think has to qualify as a good faith effort all around to look for things. We investigated a lot. There was a lot of testing in this case. Whether this was so deficient as to fall below some sort of due process norm is not a sort of standard I'm familiar with. I'm not aware of that being any sort of holding. This was presented to the jury and they weighed the inadequacies in the investigation. They were aware of this.
Counsel, one of the things I sort of, to get back to something that Judge Walker said, if we can sort of infer that maybe she cleaned herself off in a hose, given the brutal nature of the crime, I mean, what can't we sort of start to infer? Like, can we infer that given the brutal nature of the crime and her lack of injuries, that she's like a ninja and she's able to just fight him off and do all these terrible things without ever sustaining a single injury? I mean, is that rational too, that she could do that? I mean, that's part of the problem I'm seeing with this speculation. At what point are we having to speculate, you know?
Sure. So the problem here is, and with a lot of sufficiency cases, showing exactly how the murder occurred is not a thing the state's required to do. And that duty gets smaller and smaller the longer the gap is between the killing and the time of the investigation, or the killing and the time that we start investigating things. And so oftentimes we'll just find bodies and we'll connect
and the
people.
peculiar thing about this is we do know to some extent how the murder occurred because we've all these injuries on the murdered victim, right?
Yes.
But we just don't know who, really. I mean, other than that she's present.
That she's present, and there's no evidence of anyone else being present, and there is no sign, there's no motive for anyone else being there. I mean, their motive is just complete random home invasion. That's okay. That's what we call an outstanding reasonable hypothesis. But that's not a thing the jury is required to credit, and it's not a basis for this court to overturn a verdict.
Counsel,
I thought she had bruises on her arms.
She has some bruises on, certainly her upper arms have bruises, sort of as the forearm goes to the shoulder. There's pictures of her hands. There was testimony, there was no bruising on them. It looks modeled. I don't know what that means.
Okay.
well, counsel, obviously the state doesn't have to prove motive, but I mean, you just sort of mentioned random home invasion, but what's the sort of tangible, like, was there a tangible motive asserted at trial for her to do this?
No, we were very upfront with the jury that we did not know why she did this. And this was a factor the jury was given to weigh, the lack of a motive. Pardon, Your Honor?
I do have one question as well, and I realize we're over time here, but I just want to make sure I ask you this before you're gone. And that is, I'm aware of evidence that she could have tied herself up and done the other things that that there's some information someone could have done. But is there any evidence that she, for some reason, would have known how to do the things that the testimony showed that she might have done had she known how to do it? Does that make sense to you?
Correct.
Did she read a
Right.
book about a crime? Did she search something on the internet recently? Did she, talk about having watched a certain television show? I mean, how does somebody know how to do the things that might have been done by someone? And is that a gap that is too big of a gap to bridge? That's my question. I
mean, the defendant's ability to know things, and I mean, to answer your question, no, there was no evidence of that. The defense put on a computer forensic analyst who testified that he looked over their computers and he didn't find any evidence of any searching for how to claim a crime scene or anything obvious like that. So no, there's no evidence of that. And as to how big of a gap that is, I mean, we just don't know what sort of baseline of knowledge people have when they go into these things. Under our theory of the case, she had most of a day there at the house. I mean, do I know how to tie myself up with some scarves? No, I don't. If I had 5 hours to do it, I'm pretty sure I could figure it out. And so under our theory of the case, like, we don't have any evidence of her looking this up, but at the same time, there's no evidence that there was any sort of rocket science going on here, that she was not, that either A, she might not have had a baseline knowledge of, or B, she couldn't have learned during the 12 or so hours she had there by herself.
Okay. Thank you, counsel.
I thank you for your time.
Mr. Seacrest is on mute.
Can you hear me now?
Yes.
Thank you so much. I'll be brief in rebuttal. And let me kind of go backwards and try to answer some of the questions that the court has posed. Yes, she had some modeled fingernails and fingers, according to the again, the medical evidence in the record, she had Raynaud's syndrome, which causes lack of blood and causes mottling. This is clearly in the record. What the Court of Appeals did not talk about was she had serious debilitating issues here. She had lupus. That's the gold star of debilitating diseases. She walked with a cane on occasion. She had health problems, and to think that she had the ability or even the physical capability of brutally slaughtering her husband defies all logic and is, as a matter of law, not rational on this record. Judge Walker, you brought up the fact, well, could she have gone outside and washed herself on the hose? Well, we'll never know, because I specifically asked the CSU investigator to tell the jury what kind of forensic investigation did you conduct in this case. He didn't bother to check the hoses. So we can say, well, because he didn't check the hoses, now we can infer she must have gone outside and cleaned herself on the hose. That can't be the law. That can't be fair. They can't, when we establish as a matter of physical science, there was no physical cleanup at the scene. If she's the murderer, then she had to clean herself up elsewhere, but then they don't investigate that. Again, they don't even look at the cars.
So why couldn't she have cleaned herself in the bathtub?
I'm sorry?
How do we know she didn't clean herself up in the bathtub?
Because they checked the bathtub, Your Honor, and the bathtub has no of Jaime's blood is not found in the bathtub or in the sinks. The killer, everybody agreed, undisputed, that the killer would have blood all over themselves, and there is none of his blood in the bathroom, including the hot tub, including the shower.
Could the jury not believe that it all washed down the drain?
They did fluorescein test it. Well, first of all, the hot tub, the water standing in it, so nothing went down the drain. But they did check they did the fluorescein testing of the drain or the bottom of the shower. No blood.
Did they test? Did they test, like, I'm assuming, I don't know, is the closet next to the bathtub? I mean, did they check?
Yes, it is, Your Honor. It is.
Okay.
Well, let's say which closet. The closet that she was found tied up in.
Yeah, I'm wondering if they tested for blood, like if there was carpeting or tile or whatever. They just checked the bathtub. I mean,
they went into her closet, according to CSU Carpenter. He looked very carefully in the closet, on the carpet, and on all her clothes, and found no blood. The evidence shows that, and clearly, the evidence affirmatively shows no effort to clean up the crime scene. And the evidence affirmatively shows none of his blood is found in the bathroom. That is undisputed. It's a matter of law, a matter of physical science, Evans v. State.
How developed was the evidence about the suspicious person in the area? Chad?
Very little. They didn't do doodly squat. We're the ones that had to investigate that. The news media brought to their attention there was a suspicious looking person, and they didn't bother to follow up on it until one of the supervisors made them do it. They went over to knock on his door. By the way, he lives like a 3-minute walk from the residence. They knocked on his door. He didn't answer. They went to lunch, came back, knocked on his door. He didn't answer. They left a card. End of investigation. And we established he just got out of jail 2 days before for assault and had used a knife.
Let me ask you one more question about evidence and the investigation. You mentioned earlier that based on her hands and the photographs, that she could not have, beat him with her hands.
Yes,
was the investigation as to whether there's any items in the house or garage that could have been used to beat him with? Was that a doodly squat investigation also?
Exactly. That was the doodly squat as well. you know, and again, I get paid to go after police officers, but when you look at the evidence in this case, the state said, well, they investigated in good faith. I beg to differ. They didn't investigate in good faith. They were absolutely disengaged. They tried to file charges on her before the CSU unit left the house. Then they waited 18 months, did very little in the interim. One officer said that he was going to leave no rock unturned, that he was going to be in her face and she would be tired of looking at him because he was going to turn everything upside down. And 72 hours later, he didn't do anything else in the case. End of story. And I think all that's important because, again, and I'll conclude with this, when you look through the lens of Brooks v. State, Judge Hervey's opinion is that the rationality component incorporates this factual sufficiency review. And that's when you look at the character and quality of the evidence. And in this case, it doesn't even approach that which can safely say comports with the rudimentary requirements of due process of law. The evidence in this case is legally sufficient, Your Honors, and we ask that this case be reversed and a judgment of acquittal entered.
Thank you, counsel.
Thank you so much.
The court will stand in recess until 10 o'clock.